Welcome to the Startup Passport by eConsulate. Today I'm joined by Marco Molling. He's an European patent attorney for V.O patent and trademarks. Thank you for joining, and could you tell us a little bit about yourself and what you're doing?
So I was trained originally as a chemical engineer, but as a patent attorney, it's more a legal job. Mostly I help my clients in food, chemical technology, and industrial biotechnology in getting their patents protected, but I also advise them on freedom to operate kind of things, because many startups think that when they have a patent themselves, that they have a freedom to operate, but that's not the case. A patent is a right to forbid others not to use something.
So how important do you think is it for startups not only to know that they should have certain patents for certain things, but also to understand the meaning behind it, exactly what you just said? So more like educating startups on what patent actually means.
Yeah, so in addition to that, patents are a very valuable source of information, and many scientists and entrepreneurs forget that. They may look into internet, they may look into scientific publications, but maybe more than half of the technological information that is in the world is found in patents. And so also, if you don't want to file patent applications yourself, you might learn a lot from them. What you also have to think of, you can decide to file a patent application if you think you have an invention, or you can decide not to, but you have to think about it. And when you decide to do it, make very clear to yourself what you are using it for. You can try to create a monopoly, but that's, as a startup, maybe a bit of a dream. But it's very often the ticket to get you at a table in a big company or with an investor.
And what can you, as a startup or as a company, actually get a patent for? Because obviously there's also a lot of talks about intellectual property. That's also a big thing that comes in. So how does that work? Maybe you have intellectual property on the one side, patent on the other side. From which point on can you get a patent for something?
Yeah, so a patent is a form of intellectual property. Patents you can get for anything that is new, and that has some kind of technical character. And this term technical is very loose. You know, you don't have to think about machinery. It can even be a bit of a frivolous example, like if you have a very special way of doing somebody's hair, dyeing your hair or cutting your hair. It could be an invention that could be patented. And it has to be non-obvious. And so any trivial change compared to what is known is not enough to get a patent. This technical character is ironically not necessarily there when you're talking about computer programs or apps. Somehow that is not seen as technical. So there it's very much a challenge to identify something technical. But I have colleagues that are very good at that, and not myself so much. I rather stick into the chemistry and the food.
Yeah. And how much overlap is allowed in a certain process or for a certain thing that a startup might have or a company might have a patent for until it then goes too far, that there's too much overlap, that then the patent rights are...
That's a very good question, because people naively think like something has to be completely different. But one of my favorite examples is plastic, polyethylene. And so it's like this very cheap plastic that we use to wrap our sandwiches in. You can pull it apart just with your fingers without having any force. That was invented maybe in the 1930s. But during the decades thereafter, people kept inventing different forms of this plastic, not even ending, but maturing into a very strong fiber that's stronger than steel, Dyneema. That was in the 1980s. So there is overlap in the sense it's both polyethylene, but the structure chemically, but also the properties physically are incredibly different. And then you still have a patent. Maybe another example, if something very generic is known, but you then come up with a species within this generic teaching, and that specific choice that you make has a special effect, then again, there may be 100% overlap, but you have something that's new and which may be inventive and thus patentable.
And would you say that most of the aspects that you're working with right now, or if there are any certain lawsuits or infringements, would you say that these are mostly related to innovation, or to certain companies trying to build a new innovation, or can that also be past innovations that are now more the standard?
Yeah, that could be, because patents generally have a maximum lifetime of 20 years, and in pharmaceuticals it can even be an additional 5 years. So it could be something that is, and it happens, that lawsuits are, especially in pharma, lawsuits are fought over in the last year of its validity. Like my mentor, when I was still a trainee, had once a case on a very big pharmaceutical, which had in the Netherlands a turnover of, say, 1 million a day. And actually they fought a lawsuit on whether the patent expired at the beginning of the last day or at the end of the last day. So it can be that important that you even have very old things that are still sued about.
And that's then essentially also something that especially startups and scale-ups should take care of from the very beginning.
Yeah, you have to at least be aware what is around there, And I'm not saying that you have to patent, because especially in electronics or in the app world, if you, the turnover is so fast, and a product may be economically valid for like 3 or 4 years, then you have to question yourself: is it worth the effort and the cost?
Great insights on the whole topic of pattern, and very important people. So Marco Molling, thank you very much for joining.
Thanks a lot for having me here.